So I'm just gonna, right, so it's recording now. I'm gonna introduce Arletta, but first I'd like to welcome you all to the final Scotland and lightning talk. So we're going to be hearing from Arletta today. Arletta is an award-winning and committed tutor in law, teaching students of various levels, so undergraduate and postgraduate. She's currently a PhD candidate in law at the University of Strathclyde, with a Bachelor of Laws from the University of Stirling. Arletta is also the author of several brilliant articles and chapters in scholarly books, and she's got a passion for the subjects of EU law, international law, jurisprudence, and competition law. She's going to be presenting to us today, and Maritessa Maglione, apologies for the pronunciation there. Maggie is an associate professor of economic law at the Università Bocconi, where since January 2019, she's been appointed the director of the Master of Arts in Law. At the SDA Bocconi, she is the coordinator of the Let's Lab and teaches intellectual property law at the EMI LUX Master. So her research generally focuses on the connections between markets and rights, and in particular on competition law, intellectual property rights, banking law and data law. And among her eminent publications, there are monographs such as Intellectual Property and Antitrust, a comparative economic analysis of US and EU law, as well as some other brilliant monographs in Italian that I'm not going to attempt to pronounce. So yeah, I'm really excited to hear your talk, Arletta. I'm going to hand over to you. Then we're going to hear some comments from Maggie, and then we'll move on to some questions. And yeah, I'm going to hand over to you then, Arletta.
Great, thank you very much. So thank you very much for inviting me to actually conclude our series of enlightening talks. And I'll be just presenting a little piece of my PhD thesis. Obviously, like I'm going to be honest, like I'm switching off my video on the basis that I don't trust my internet. So I really prefer to show you my presentation rather than to show you my face. So the topic of today's presentation is the other side of the coin: privacy justification and anti-competitive proceeding under Article 102 of Treaty of Functioning of European Union. So why basically we're going to speak about privacy justification, because I do believe that we generally place a huge emphasis on actually recognizing if any privacy infringement could be seen as competitive harm under Article 102 of TFEU. But basically, I do believe that also this topic is quite left in the shadow, because we do focus on trying to see to what extent we can acknowledge, obviously, extensive data harvesting and also potential privacy breaches as a part of competition law infringement. But almost we've not really focused on what happens if digital undertakings do recognize that if we ensure privacy level has increased, to what extent we can avoid their anti-competitive liability. And in this respect, I'm going to focus on two recent developments introduced by Google and Apple. And essentially, these are Google's privacy sandbox and Apple's ATT. So before we really have focus on the law, let's briefly focus on what are those developments. So basically speaking, both of those two developments, they do appear to introduce better privacy protection for the users. And both Apple and Google they both changed the privacy policies, and that could really impact the product they offer. And both initiatives do aim at limiting the third parties' cookies. So obviously that would allow third parties technologies to track digital users with their consent. And obviously such product upgrade of such essence could really impede third-party advertisers' ability to track online users and obviously offer product advertisement. Obviously, those two both proposals, they have very broad implications, and they're probably going to leave us regulators busy for another years to come as to what extent we can see them fit in the realms of competition law. But basically speaking, Competition and Market Authority in UK, they do recognise that such privacy-related change could allow users as one consistent identity whenever and wherever we, Google see them. So actually any challenges that were introduced by Google and Apple, they might have ramification for ecosystem participants. And in theory, this could allow them to act as de facto privacy regulators. And importantly, such powers could typically extend beyond the GDPR and any privacy law with different operational options. However, Google's enable pro-privacy amendments, which limits third-party tracking, do not imply that users' tracking will be completely eliminated. Both initiatives do not prohibit collection and the use of first-party data for the purposes of targeted advertising. And essentially, the Google's privacy sandbox has been really scrutinized by competition authorities, and CMA extended their concern to say that the Google's privacy sandbox eventually they launched a formal investigation aiming to ensure that both privacy and competition concerns can be addressed as privacy sandbox proposals are developed. So what could it mean in practice for us if it comes? So essentially, privacy sandbox, it does hinders the privacy third-party cookies, but does not constrain online tracking. So in other words, Google will still keep to have an access to a large amount of user data from services such as Gmail, Google Maps, Google search engine, and that could be still a source of a very lucrative ad customization. This phenomenon could eventually lead to pervasive surveillance, which is the collection of data from users participating in a specific network by the device used to participate in such networks. So eventually what it could mean, I also tried to move what Facebook is doing, and I'm sure we all are familiar with the famous German case about Facebook being, Facebook infringing the competition laws, merging the data from third-party websites. So eventually companies like Facebook and Google's, they might have an access to collect even further amount of data. And surveillance of such platforms, in my opinion, could cause exploitative harms to society and online users. The privacy sandbox has no effect on such procedure, which could take place on any popular websites. But basically speaking, if digital firms such as Google were involved about the user's privacy, they would potentially use, as CMA suggested, they could potentially look at limitation principles. And secondly, the challenge to privacy sandbox could be eventually perceived as unfair terms of contract with Google under Article 102 of Treaty of Functioning of European Union, as Google's privacy amendments might have significant effects on users, because obviously the terms of condition, they will be changed and they will be still ambiguous and quite difficult to estimate. And I do believe that such phenomenon could have two-side effects. So on one side, privacy sandbox eliminate cross-site trackings, which obviously could enhance the quality, the privacy quality of Google. And this is, of course, a consumer gain. However, such advantage might be also restricted since privacy sandbox does not reduce surveillance on popular digital platforms such as those operated and owned by Google. But on the other hand, we do have less exploitation to less relevant advertising, which could potentially equate with loss of welfare for consumers who value the relevant advertising. But basically, if we do look at that as a whole, and Google and Apple will be caught as infringing competition law by the virtue of changing the privacy offered by the website, what defense can they use? So eventually I'm going to focus on efficiency defense and objective justification. So let's have a look at the efficiency defense first. So generally, efficiency defenses justify the anti-competitive business practice when it introduces the positive competitive effect. Essentially, the nature of this defense was really discussed in the case where Microsoft tied up Windows Media Players to its operating system. And Microsoft defense was really that when you do have the Windows Media Player tied to the system, it really resulted in a cost-saving activity, as obviously the consumers will no longer be required to set out a different channel for media player distribution. Yet eventually the Commission held that such argument was basically irrelevant, as the cost remained absolutely low. Absolutely low. So from the latest cases, we can eventually look at the Google Shopping case, which also provided judicial interpretation of efficiency argument. The Google Shopping case judgment really elaborated on the treatment of such defense in the context of the abuse of dominance, building on the analytical framework which was established in a post-Denmark case. This is where the Court of Justice of European Union established that the efficiencies must be pictured regarding their actual existence and their extent. As also we have in this case established that there is a need for causal link between alleged improvement and the anti-competitive conduct. But really the court insisted on the benefit of consumer choice. So if we suppose that Google Shopping case indicated generating efficiency by improving consumer experience, it did not justify the Google's anti-competitive conduct, as really the conduct materializing the improvement led to harm in competition by reducing shopping services available to the consumers. So how would that eventually work when we do apply privacy protection perspective? So really the question would remain as to how, if at all, do efficiency play any role in influencing privacy protection, and is it able to maintain privacy risk as recognizable efficiency argument in EU competition law? So I carried out the evaluation of privacy concern on EU competition law, and it really came from aspects on EU competition law not recognizing the intersection between competition law and privacy in the case of Asnet and Switax, to potentially bring it in when we do have those two mergers of Microsoft and LinkedIn and Facebook with WhatsApp, when the Commission indicated that privacy is not main but important factor of competition, which was recognized as really as a quality parameter, to eventually AG Rantos recognizing that any incidental breach of GDPR could give a rise to anti-competitive conduct. So essentially, I assume that firstly, efficiency innovations are essential for maintaining a healthy market function. So when we do really limit the issues at factor that boost efficiency, that could represent a quite narrow-minded view of innovation. The digital market really illustrates the need for dynamic efficiencies, which are innovation, of course, because that stimulates the market's dynamics while also reducing the marginal return. So platforms commonly manage complex expectation, and that obviously results in increased users' privacy level, and any adjustments to platforms practice could correct potential market failure. Platform ecosystem amendments in contract should not be really viewed as a threat. If we do assume that any amendment is indeed harmful, act seems really unaverted. Obviously, the usual criticism could equate with the debate denouncing that the incorporation of non-economic factor in evaluation of the competition law. Due to the reliance to intervene in cases which involve direct express pricing, obviously we have no expectation why end users' privacy should serve as a mean for competition authorities to act. And by the way, the question suggests that we might have the gap that is not inevitably whether the implementation of competition law is insufficient in evaluating privacy concerns. But the problem really resides with the GDPR implementation, because essentially the GDPR does not recognize the long-term harms with the data exploitation. But basically also competition law should not be extended beyond its natural limits, and public policy should not be based on evaluation of efficiency and competition merely. This would really appear to suggest that the market mechanism as competition law are quite unequipped to promote higher degree of privacy. And secondly, we could assume that if privacy consideration could be considered methodologically by competition analysis, then if we do integrate privacy, we would require a coherence perspective. So it's inappropriate to consider the negative facet of privacy while excluding any counterpoints predicted on the same. And similarly, this is really the point that we consider on the green transition. So essentially, recently Commission forbidden a manufactured conduct that restricted the advancement of less polluting emission system. However, also we have an evidence of possible conflict between competition law and potential sustainable development, which was really demonstrated by adoption of revised horizontal guidelines. There are obviously numerous explanations to start examining possible dimension with the terms of competition and privacy. Their interconnection, as we know, is complicated and really stretch beyond the field of what we know about competition law, as also privacy is a very social concept and is quite difficult to be defined through the lens of competition law. And also the users, they rarely have a chance to discuss and negotiate the level of privacy provided by platform providers. Obviously, digital society keeps still evolving, and there are new vulnerabilities and threats rising, and the connection between competition law and data protection at hence could become a bit much more confusing. So I do believe that at the stages remain quite unclear whether Apple or Google could indeed rationalize their project as being efficient. Apple blocking third-parties app from accessing data required for app customization might be perceived as refusal to supply as per Google Shopping case. Apple's viewed the changes that affect third-party data as being outside the scope of their concern, and also, I do believe that Apple's practice, just like the Google Privacy Sandbox, could potentially continue to compromise users' privacy. And also, when we do try to attempt the Google's attempt to defend their conduct through efficiency argument, it seems to be inofficial as well. So there really is the main reason that for this theory of harm construction, it remains unclear as to what if Google could immediately increase utilizing third-party tracking to inform its advertising business. And also by removing cookies, Google restricts consumer choice, especially for those users who tend to value online advertisement. And it's unclear, regardless of whether Google is prepared to launch a different, more equitable alternative with the same level of potential personalization. Moving forward, another dimension that we can look at is the privacy under objective justifications. So again, so generally speaking, this is really another method for avoiding liability under European competition law, and it's through the objective justification. So it's really external factor which extrapolates the exclusionary abuse. And obviously, according to Commission, there are only a limited number of non-competition policies, as well as referred to external to competition law policies that can reduce the harm caused by that particular anti-competitive conduct. And they do include non-competition law policies such as protection of employment, media pluralism, and environmental protection or regional development. So these are actually those that are legitimate when we do apply Article 101, subsection 3 for reviewed agreements. Obviously, the standalone arguments remains that competition law is not really a self-standing statute, but is a part of larger framework of Treaty of Functioning of European Union. And the research really suggests that there are potential for possible outcomes for collaboration of external to competition policies with competition law, and they do are, for instance, that potential external policy value tends to overshadow and exclude competition policy. Secondly, if we have infringement of competition law, it could be balanced. Competition law could indeed then act as a complementary procedure. Then we can have a policy linking or cross-sectoral clauses. And lastly, the last scenario could relate to the silence of the treaty. Obviously, due to the practical issues in its application, objective justification is frequently criticized because there are practical difficulties in really differentiating anti-competitive behavior from its justification. And I'm not aware of any examples where we can use the objective justification really as reducing the anti-competitive behavior. From the perspective of the privacy, neither national nor competition law at the present, they do not recognize an obligation to safeguard privacy as a proactive implementation of Article 102. Obviously, that particularly comes from the case of Asnes ex Quitex, where we have the courts rejecting an interplay between competition law and data protection. However, the relationship between competition law and privacy is quite much more complex and much more nuanced, and I do believe that this intersection is quite novel. In fact, the data protection and competition law, they do share fundamental concerns about and approaches on mitigating unfairness by introducing and imposing obligation on those with market powers. And due to the relationship between sector-specific regulation and competition law, referencing privacy as the ground for objective justification could potentially be problematic. And I'm using the case of AstraZeneca, how compliance with other legal orders have no impact on whether an undertaking has abused its dominant position. So in fact, any violation of other legal orders does not automatically would imply that we do have a violation of competition law. When we do really look at this reasoning, it will be impossible for a dominant undertaking to seek justification for its anti-competitive behavior by citing compliance with, for instance, data protection legislation. Obviously, I do believe that such reasoning appears to be quite plausible because it avoids extending competition rules to capture the harms that are basically outside the scope of competition law. A recent case law appears to dual this problem. So, for example, when we do look at the case of Slovak Telecom, a regulatory obligation can be relevant for assessment of abuse conduct, where an undertaking is subject to specific sectoral obligation. So in perspective, there's obviously tension between this judgment and what was discussed in AstraZeneca and Slovak Telecom. So for example, under AstraZeneca, Article 102 could disregard an undertaking's position and a regulatory regime in question. However, in Slovak Telecom, we do have appointed an apparent relevance of regulatory regime in question for the purposes of Article 102 applicability. And it's really unclear whether such a reconciliatory reading could presuppose that regulatory context could play a part of anti-competitive conduct. Also in Google shopping case, the court considered external for competition law policy for the sake of compliance assessment. And also we do have A.G. Ranto's opinion recognizing that incidental consideration of external for competition law policies could be relevant, as competition law harm would not exist if we don't have this policy violated. So obviously it's argued that there are significant implications for the role of privacy as objective justification. So we really, if we do assume that AstraZeneca approach is inappropriate, then Google and Apple conduct should not respond to GDPR compliance argument in order to avoid any anti-competitive scrutiny. In this regard, really, a theory of harm should not be established based on an infringement of any different legal rules. So here, even if the development of the digital society has an increased competition authorities interest in privacy-related theory of harm, we really shouldn't be looking at this as expanding the competition law legal order to any other areas of law, such as data protection, because essentially for this reason, the competition law will be used to remediate and punish, obviously, those undertakings that harm the competition law and would impact on the healthy functioning of the market. So I will elaborate on that a bit further. So if a dominant undertaking is found in violation of Article 102, the undertaking could potentially argue that the conduct is completely beneficial, or could demonstrate that the conduct is incapable of demonstrating a competitive effect. So here, if we assume that the conduct was pro-competitive, such situation would constitute an ancillary restraint. However, if a company claims that the anti-competitive conduct is proportionally pursuing non-economic goals, then we can look at the case of Volters, which suggested that behavior cannot be viewed as intercepting ideas. So hence, the question really remains whether platforms can claim that the anti-competitive behavior or infringing or promoting privacy is indeed pro-competitive. I do believe that such answer should remain negative, and the question should be really answered through the involvement of government power as to whether it is legitimate to pursue non-economic consideration. And accordingly, Google and Apple can only rely on the non-economic consideration if they are granted regulatory powers. And this conclusion is really still questionable, as EU competition law does not see such regulatory vigilance as complementary. And also quickly adding, if in the context of Digital Markets Act, Google, which is obviously unquestionably a gatekeeper, will unlikely to be granted any extra degree of authority. When the cases of ATT and Apple Privacy Sandbox are discussed, I still believe that their relationship with using their conduct together with objective justification remains sane. I do assume that they would be quite blurry. Like I've mentioned, the EU competition law does not view such regulatory vigilance as really favorably. And I assume that DMA makes really no provision for gatekeepers to avoid liability for increased privacy protectionism. So regulatory consideration have been deemed important for justifying the existence of harm theories under Article 102 of the treaty. And furthermore, in EU competition law, they could be regulatory compliance to inform the assessment of any long-running anti-competitive cases. And at the time of writing my article and my thesis, is really unclear how Commission could decide to enforce actions against undertakings that promote products privacy as objective justification for their anti-competitive behavior. So briefly to conclude, and to give a bigger picture in my thesis, I really looked at those two elements of Privacy Sandbox and Apple AT&T as potentially demonstrating an exploitative theory of harm. And I really tried to see to what extent they could have avoided liability if they went either they wanted to use the efficiency defense of objective justification. To summarize, they those both attempts, they do try to block third parties data collections, and which arguably seems to expand their own databases. But at the time of writing, it's really quite unclear on how Commission could potentially accept those defenses. So thank you very much for listening. And I'll be thankful for any comments and suggestions you might have.
Thank you so much, Arletta. That was a really brilliant presentation, really fascinating deep dive into those two different sort of perspectives, the privacy perspective and the competition law perspective. So we're going to hand over to Maggie now for some comments, and then we'll take some more general questions from the rest of the audience. So Maggie.
Okay, thank you very much. Thank you, and thanks for having invited me here. I'm very happy to share my time with you discussing such a interesting topic, a very cutting edge topic. So congratulations, Arletta, you found a wonderful, oops, my camera. As I was saying, you found a wonderful topic to discuss together. Now, I have some comments about it, okay? First of all, you are talking about Google's and Apple's conduct to improve privacy, to become more privacy friendly. And if I look at those two conduct, I would say, as an antitrust lawyer, that first of all, they should be considered or qualified as exclusionary and anti-competitive conduct. I mean, the impression that I got by reading your interesting paper is that by blocking the tracking of third parties while still allowing its own tracking, Google is excluding competitors and harming consumer welfare. Therefore, first of all, I will try to analyze this conduct in this way, as an exclusionary and anti-competitive conduct, not as an exploitative one. Also because when it comes, to exploitative conduct, then what you have to show is that the clauses, the terms and conditions of your privacy policy are unjustifiably unrelated to the purpose of the contract and they do unnecessarily limit the freedom of the parties. They are disproportionate, they are unilaterally imposed, or they are seriously opaque. I mean, you cannot argue that a conduct is exploitative just because it harms privacy. You have to argue that the terms and conditions of the privacy policy are unfair because of the way they have been written, because of the way they have been shared with users, because of the duties they impose in an unjustifiable way to users. So before getting to, as a first impression, I would not consider Google Sandbox, privacy sandbox, as exploitative. I mean, you run the analysis by saying, on the one hand, it is more privacy friendly than before because it blocks third parties' tracking activities. Okay, so from this side, it wouldn't ever be exploitative. On the other hand, it is exploitative because it doesn't limit surveillance. I don't know how to pronounce it correctly in English, but this idea that they watch over us or wherever we are. Well, but this is not an issue that was caused by Google Sandbox. This is an issue that is already there and that Google Sandbox does not solve. So it is not a consequence of the change that was produced by Google. So you cannot consider it as an effect of Google conduct. So as my understanding of the facts, that probably is not correct, I would try to characterize the conduct of Google and Apple as exclusionary and anti-competitive and not as exploitative. Nevertheless, this kind of characterization as exclusionary and anti-competitive could be very useful for your argument, because I'm not sure that the efficiency defense that you have brilliantly analyzed can be used against exploitative conduct. Are you sure about that? I'm not. I've never studied this issue. But the efficiency defense, as it is presented in post-Denmark and Intel, generally is used to save exclusionary conduct that do not harm consumer welfare. It is not used to save exploitative abuses, because actually exploitative abuses have nothing to do with the functioning of the market. They have to do with fairness. So efficiency considerations are not a matter of what can be exploitative or not. If I was not clear with you, there's no point about efficiency. Efficiency can be a justification for exclusion. So probably characterizing Google's conduct as exclusionary and anti-competitive would help you to explain why it could be justified with efficiency arguments. So let's switch to your analysis of the efficiency defense under Article 1 or 2. I agree with what you said, but I would recommend, well, I agree with what you say, because if I get it right, you go straight to one point. Well, to be clear for everybody, consumer welfare depends on 5 variables. It's not something that we don't know what it is. It depends on 5 variables: prices, output, quality, variety, innovation, period. You can argue that consumer welfare increases if prices go down, quantity goes up in the short run, and whether in the long run, quality, variety, also called consumer choice, and innovation go up. You argue that consumer welfare goes down when these variables change in the other direction: price increase, output decrease in the short run, variety, innovation, and quality decrease in the long run. Now, so not everything is consumer welfare increase, not the fact that not everything can be consumer welfare increase. How can you drive a privacy consideration within this framework? By saying that thanks to privacy, thanks to products which are more privacy friendly or systems which are more privacy friendly, the quality of your product increase, or the variety, so the consumer choice increases. If you do this, you could say that you have a consumer welfare increase because of quality increase or because of variety increase, thanks to privacy issue, privacy policy. Now, on the one hand, you have this. On the other hand, you have the other effects on consumer welfare, as Arletta says. So you may find yourself in a situation where a conduct increases consumer choice, increases the quality of product, but increases prices as well. So you have 2 different effects on consumer welfare. You have a price increase or an output limitation that brings down consumer welfare. And then you have a quality increase, a variety increase, and innovation increase that brings up consumer welfare. Which of the 2 should prevail? Now, this is not a matter of economics. This is not a matter of law. This is a matter of policy. This is in the US and in the EU, it is clear that as long as we are capable of increasing innovation, all the other effects do not count so much. But that's a policy decision. It's not something that we measure. Because every time we go, we think that we should make a balance between the pro-competitive and anti-competitive effects of things, while actually the courts do not balance anything. they try to have different narratives, different storytelling. The theory of harm that ends with the anti-competitive effects, so price increase, output limitation, reduction of innovation, and the theory of the defense that comes to showing that oh, there was an innovation increase or a consumer choice increase. And then they look at the evidence and they find out, and they try to find out which of the two narratives is more grounded. So I agree with what Arletta says when she said that we have to find a hierarchy among these 5 variables if we want to take into consideration privacy issues. But then privacy issues come within the antitrust discourse via quality increase or consumer welfare or consumer choice, or in case via innovation. So if the question in the end is, can we use privacy issues to create efficiency defense? The answer is yes, as long as we describe privacy increases as quality increases, consumer choice increases, innovation increases. And then it comes the third big question that Arletta discussed in her paper. Which is about not the efficiency defense that, let me say it again, I would use against exclusionary conduct. I don't know if I could use it against exploitative conduct. But the third part of the paper is devoted to objective justification. Can we use privacy enhancing tools or privacy friendly arguments as an objective justification for anti-competitive conduct? So the case would be, I got an exploitative conduct, or even I got an exclusion and anti-competitive behavior, but still they are lawful because they are objectively justified by these external arguments. And this is a very difficult issue, and I make my compliments to Arletta because she was brave enough to face it. It's a difficult issue. Why? Not only because of this idea that there are economic and non-economic goals of antitrust law, but because one thing is saying there is a piece of law that says that you have to take that conduct. And one other thing is saying there is a piece of law that wants you to pursue one goal. And the possible conduct you can undertake in order to pursue that goal are many. And you have chosen one of them that meanwhile is also anti-competitive instead of another. So in that case, I would say I appreciate the intent of pursuing a better privacy-friendly world, but if you do it via an anti-competitive conduct, I do not admit that the pursuit of privacy as a justification, because there could always be less anti-competitive way to achieve that goal. So I don't know if I were clear because I didn't prepare slides for making the discussion. Then I will share with Arletta my thoughts, my comments on her paper. But my arguments, well, my points are 3. First of all, I would try with a different characterization of the conduct as exclusionary and not as exploitative. And I believe that in this way, the switch, then the jump within the paper to the efficiency, the justification would be easier also for the reader. When it comes to efficiency justification, I agree with Arletta. We need to find out a way to drive privacy consideration within the framework of consumer welfare analysis, knowing that there are ways to do that. We can use privacy consideration to discuss quality increases and consumer choice increases and also innovation increases. And then we have to take a policy decision if those effects come together with other effects on prices, output, and other variables. And third, when it comes to the objective justification, I would try to find a way to distinguish between the case where the conduct chosen is the only one available, and so you face the clash between the political goal you want to pursue and the conduct which is anti-competitive, from the case where the political goal you want to pursue is there, but the available conduct to realize it are many, and you have chosen, what a case, just the one who is the more anti-competitive possible. Thank you.